Here is something that will change how you read property law forever. The Transfer of Property Act says property of any kind may be transferred. That is the golden rule. But Section 6 exists precisely to destroy that assumption in exactly 10 specific situations. And here is the thing nobody tells you. These 10 exceptions are not random. Every single one of them follows just two logical pillars. Once you understand those two pillars, you will never need to memorize this section again. Pillar 1. You cannot transfer what you do not legally possess yet. Pillar 2. Rights that are strictly personal or rights tied to public policy cannot be separated from the person holding them. That is it. That is the skeleton of the entire section. Now, let us build the flesh on it. We start with Clause A. The Latin term is Spes Successionis, and the moment you break it down, Spes means hope, Successionis means succession. It literally means the hope of inheritance. And the law says you cannot transfer a hope. You need a present, vested legal interest, not a probability, not an expectation, a real right now. So think about this. A father is old, terminally ill. His son B is absolutely certain Papa is going to leave me this house. B is so sure that he sells his future half share of this house to X today, takes the cash, and moves on. What happens? That transfer is void ab initio, completely null, because B is what the law calls an heir apparent, someone who will probably inherit but has zero legal right now. The father could sell the house tomorrow. He could write a will giving it to charity. He could outlive his son. B has nothing transferable in his hands today. Now, here is where it gets genuinely interesting, and this is the trap that has destroyed countless exam attempts. What if B does not tell X the truth? What if B walks up to X and says, I am the owner of this house right now, buy it from me? And X, believing him, pays the full price. Later, the father dies, and B actually becomes the owner. Now what? This is not Section 6A anymore. This becomes Section 43, feeding the grant by estoppel. Section 6A applies when the buyer knows they are purchasing a future possibility. Section 43 applies when the buyer is misled into thinking the seller has present authority. In that case, the moment B actually gets the ownership, the law feeds the grant, X can claim the property. So the same situation, depending on whether there was fraud or full disclosure, leads to completely opposite legal outcomes. That distinction is gold in an objective question. Now, Spes Successionis covers three specific types of mere possibilities: the chance of an heir apparent inheriting, the chance of receiving a legacy through a will. Imagine a servant hoping their master will leave them the house in a will. They cannot sell that hope. And any other possibility of a like nature, for example, future wages that have not yet been earned by a servant. None of these can be transferred. All void. And just so you know, this rule of non-transferability of Spes Successionis is not unique to India. English law follows it. Muslim law follows it. Punjab state laws follow it. It is a universally accepted principle rooted in pure logic. You cannot sell what you do not own. Now here is where it gets really interesting. Clause B. Mere right of re-entry. Let me paint the picture first, then give you the legal rule, because that is the only way this sticks. A landlord A leases a house to tenant B. The lease deed has one condition: do not alter the structure of the building. B, 6 months in, decides to break a wall. A now has a legal right, the right to terminate the lease, evict B, and walk back into possession of his own property. That is the right of re-entry. It is a powerful right. Now, A has a problem with his neighbor C, who is very aggressive and has muscle. A thinks, let me sell this right of re-entry to C. C can go evict B, and A will get his money. Can A do this? Absolutely not. A mere right of re-entry cannot be transferred separately from the property. Why? Because this right is a personal license connected to the land itself. It protects A as the owner. If you detach it from ownership and sell it alone, you are essentially selling the right to dispossess someone, and that is a recipe for chaos and coercion. But here is the flip side, and this is where the exam catches you. If A sells the entire house, the entire ownership, to C, the right of re-entry goes with it, automatically. Because the right is attached to ownership. Transfer the ownership, the right follows. Transfer only the right, leaving ownership behind, void. That distinction is everything in Clause B. Moving to Clause C, easement apart from the dominant heritage. Now the word easement might sound technical, but the concept is beautifully simple. An easement is a right enjoyed by one property over another property. The property that gets the benefit is called the dominant heritage. The property that bears the burden is called the servient heritage. Classic example. A owns a house. To reach the main road, he must cross his neighbor B's land. A has a legal right of way across B's land. A's house is the dominant heritage. B's land is the servient heritage. Now A needs money urgently and thinks, I can sell this right of way to C, who runs a delivery business and needs shortcuts. A will keep his house, just sell the right. Invalid. An easement cannot be separated from the dominant heritage. It is irrevocably attached to it. The right of way exists because A's house exists and needs access. The moment you sever the easement from the house, it has no legal identity of its own. But if A sells his house to C, the easement automatically moves with the house. It is not separately transferable, but it is automatically transferable as part of the dominant heritage. Same principle as Clause A. It follows the whole, not the part. Now, Clause D, restricted interest. And this is where the law gets deeply human. Some rights exist because of who you are, your personal qualification, your identity. You cannot transfer those rights because they are not really property. They are extensions of your person. Classic exam examples here are about religious offices. The right of a pujari or shaibite to perform puja at a temple, the office of a mahant of a math, the office of a mutawalli of a waqf. These are not transferable because they are granted to a specific person based on their qualifications, lineage, or appointment. A Maha Brahmani has the customary right to officiate funeral ceremonies and receive offerings. She falls sick and thinks, let me transfer this right to my cousin for the month. She cannot. The right is hers by personal qualification. It cannot be delegated or sold. A teacher's right to teach on a particular platform under a personal appointment. That is also a restricted personal interest. The pattern is always the same. If the right only makes sense because of who the person is, it cannot be transferred to someone who is not that person. But this next part is what nobody talks about. Clause DD, right to future maintenance. And before I explain the rule, let me tell you something about the history of this clause that makes it unforgettable. This clause was not part of the original Transfer of Property Act of 1882. It was inserted by the Amending Act of 1929, and the reason it was inserted, there was a massive, embarrassing split between two of India's highest courts. The Madras High Court had ruled, if maintenance is secured by a court decree, it becomes a crystallized debt, and therefore it is transferable. The Calcutta High Court had ruled, maintenance is a purely personal right, and it can never be transferred, decree or no decree. Two courts, two completely opposite rulings. The legislature had to step in. In 1929, the legislature sided with the Calcutta High Court, inserted Clause DD, and settled it forever. The right to receive future maintenance is non-transferable, period. It does not matter if it is awarded by a court decree. It does not matter how formal the order is. Future maintenance is personal. It is granted for the survival and dignity of a specific individual. If you allow it to be transferred, the person it was meant to protect ends up with nothing. Now here is the trap, and I want you to get this perfectly, because this exact distinction has appeared in exams multiple times. The rule is about future maintenance. What about past maintenance that has not been paid? Think about this. A wife is entitled to receive 10,000 rupees per month from her husband. He has not paid for the last 6 months. That is 60,000 rupees in arrears. Can she transfer the right to collect this 60,000 rupees to a third party? Yes, she absolutely can, because that 60,000 rupees is no longer future maintenance. It is a past debt. It is crystallized into an actionable claim, a fixed, certain, calculable amount of money owed to her. Actionable claims are transferable under Section 1030T_TPAA. The moment the maintenance period passes and becomes arrears, it transforms from a personal right into a transferable debt. Future maintenance, non-transferable. Past maintenance in arrears, transferable. Write that down in your brain permanently. Now Clause E, mere right to sue. And this clause is built on one of the most important policy decisions in civil law. The law does not want litigation to become a commodity. It does not want a world where people buy and sell lawsuits for profit. That practice, buying someone else's right to sue, is called maintenance and chempity, and it is deeply opposed to public policy. So the rule is, you cannot transfer a mere right to file a lawsuit. If A hits B and causes injury, B has a right to sue A for damages. B cannot sell that right to C, so C can profit from it. But, and this is where the real exam trap lives, not every right to recover money is a mere right to sue. There is a critical distinction between unliquidated damages and liquidated damages. Unliquidated damages mean the amount is not yet determined. It depends entirely on a judge's assessment. A punches B and causes some injury. How much compensation is B entitled to? That number does not exist until a court decides it. This is a mere right to sue, non-transferable. Liquidated damages mean the amount is already fixed and certain. A borrowed exactly 10 lakh rupees from B and has not repaid it. The amount owed is precise. There is no judicial guesswork needed. This is an actionable claim, transferable under Section 130. So the test is always, does the exact amount exist right now, or does it still need a judge to determine it? If it needs a judge, it is a mere right to sue. If the number is already there, it is an actionable claim. Now here is where it gets really interesting. Clause F, public office and the salary of a public officer. Think about what a public office really is. A judge, a senior bureaucrat, a government official. These positions exist not for the personal enrichment of the person holding them, they exist for the service of the public. If you allow a public officer to transfer their office or to pledge their future salary to a private creditor, You compromise their independence entirely. Classic scenario. Officer A owes a gambling debt. He signs a contract saying, "My entire government salary for the next 2 years will be deposited directly into your account." Is this valid? No. Future salary of a public officer is non-transferable. The policy reason is the same as with maintenance. It is granted for the dignity and independent functioning of the individual. A government officer who has pledged his entire salary to a moneylender is not a free, independent, functioning officer. He is a captive. But here is the important exception. The moment the salary is actually credited into the officer's personal bank account, it stops being salary in the legal sense. It becomes his personal money. At that exact moment, he can pay debts with it, transfer it, do whatever he likes. The non-transferability attaches to the right to receive future salary, not to money already in your possession. Clause G. Stipends and pensions. The same logic extends here. Pensions granted to military pensioners, naval pensioners, Air Force pensioners, civil pensioners, and political pensioners, all non-transferable. These are granted by the government for the dignified survival of people who have served the nation. The policy is identical. These exist for the person, not for their creditors or assignees. Now, Clause H. This is the catch-all clause, and it covers 3 different situations bundled into one. First, transfers opposed to the nature of the interest itself. If you transfer a residential property with a condition that the buyer can only use it to grow mushrooms and can never sleep there, you are fundamentally destroying what a residential property is. Such a transfer is opposed to the nature of the interest. Second, unlawful object or consideration. Any transfer whose purpose or payment is illegal under Section 23 of the Indian Contract Act is void. If you transfer land in exchange for covering up a crime, the consideration is unlawful, void. Third, legally disqualified transferees. And here's the trap that appears in objective questions with brutal frequency. Under Section 136 of the TPA, a judge, a legal practitioner, or any officer connected to a court is completely disqualified from purchasing an actionable claim. Why? Because if a judge could buy a debt and then preside over the case to recover it, the conflict of interest would be catastrophic. Section 136 bars this absolutely. So when an MCQ gives you a scenario where a judge buys a debt claim, do not think twice. That transfer is void under Section 136, read with Clause H of Section 6. And finally, Clause I, untransferable right of occupancy. This clause was added to the TPA in 1885 specifically to resolve agrarian land disputes. 3 categories of people are prohibited from transferring land under this clause. 1. A tenant who holds an untransferable right of occupancy. He can live on the land, but he cannot sublease it or sell his occupancy to anyone else. 2. A farmer of an estate who has defaulted on paying land revenue to the government. His right to occupy is already compromised by that default. He certainly cannot transfer it. 3. A lessee of an estate under the management of a court of wards. The Court of Wards manages estates on behalf of those who cannot manage their own affairs. A lessee in such an estate cannot transfer his lease. And that brings the full circle closed. 10 clauses, 2 logical pillars underneath all of them. Either you are trying to transfer something you do not legally own yet, or you are trying to detach a right that is too personal, too tied to public policy, or too connected to a specific identity to ever stand alone. Now go back and ask yourself, in which of these 10 clauses does both pillars operate simultaneously? Think about it. because that reflection is exactly the kind of thinking that separates a student who reads this section from one who truly owns it.